Thanks for being here, everybody. This is another webinar in Miller Johnson's Lesson from Litigators series. Today, we are going to be covering the very often complicated area of reporting abuse and neglect of children. We are also going to be covering duties to warn third parties of threats of harm and when those duties arise. And then we're also going to click very generally on when duties arise for reporting harm or threatened harm or crimes upon adults, whether these are vulnerable adults, exploited adults, or just any adults. There is a body of law out there, both statutory and common law, that places these duties upon certain individuals, depending upon their position. And there are severe consequences if, in fact, a duty has been imposed and you don't comply with it. My name is Dick Hillary. I am a litigator here at Miller Johnson. I've been litigating as a general commercial litigator for the better part of 20 years. And my practice area is fairly broad in litigation, but it focuses primarily on healthcare counseling. And it has found itself moving into this area fairly often recently, but certainly over the last 20 years, I have been contacted about this subject matter. The client calls and shares a fact pattern with me. There's a concern about a risk of harm to somebody. What do you do? Who do you call? Can you call even? And these questions seem to be becoming more frequent in my practice. And so we thought it would be a really good time to give this presentation. And then I'll let my partner, Neil Marchand, introduce himself.
Good morning. My name is Neil Marchand. I am a litigator here with Dick. I've been at Miller Johnson 11 years now, after clerking on the federal court here in Grand Rapids. I got involved in the mental health space about 7 years ago. My wife's a psychologist, and so friends were contacting her to ask me, what do you do when something like this comes up? And so that's when Dick and I started the mental health law practice group for providers here at Miller Johnson. I also focus on fiduciary litigation, which is wills and trust disputes and insurance coverage matters for policyholders. I like to sue insurance companies. So Dick's going to kick us off today to introduce the topic and to get us rolling.
So like I kind of previewed, we are going to cover a couple of different areas today. I would say the most important of which involves obligations regarding children. Quite frankly, because our legislature and the courts have placed the health and welfare of children really at the top of our list of policy concerns, not only in Michigan, but in the country at large. But in doing this, we didn't want to leave out other reporting obligations involving adults, and whether these adults are in the mental health care system or just adults generally. So there are at times reporting obligations, even when we, depending upon our position, have information that an adult is threatened or harmed, and we wanted to make sure we at least put that on your radar. Now, I checked the registration list today, and we have really a fairly broad group of people who are listening. Many of you are clinicians, and by that I mean you're licensed in the state of Michigan to provide healthcare to whatever your license covers, whatever part of the population your license pertains to. And one of the issues that comes up in this area of reporting obligations fairly frequently is this tension that we find between obligations that clinicians have to their patients to maintain confidentiality, and then pulling against that obligation is the counter obligation that finds itself in statutes and sometimes in case law to actually breach that confidentiality and make a report. And that usually arises under circumstances where if you don't make that report, there's a likelihood or a potential of harm to somebody. And so this tension comes up under the law. It is addressed in almost all of the clinicians, depending upon your code of ethics. It's described in there. It's a challenge that clinicians have and are faced with on a fairly regular basis. So we're going to talk about that a little bit today and see if we can give you some solutions or at least some benchmarks that you can apply when you need to make these very difficult decisions. And we've come to describe this space that we are going to be addressing as the intersection, right? The intersection of your ethical obligations to maintain confidentiality, weighed against your duties to reveal that confidential information. When must you do that and when can you do it are very important questions to the clinical community. So we threw a couple of statutory sites up here. I'm an attorney, and it's not uncommon for me to jump into WebMD because I think I can understand what clinicians do. I can't, obviously, but we as lawyers are doing this regularly. But we also know that many of you, these statutes are written in a manner so that anyone can read and understand them. You don't have to be a lawyer. And so we wanted to give you at least the idea of where you can look, should you be interested, to find these obligations statutorily. And so the four most important statutes are cited on this slide. They deal with the duty to warn third parties. When must someone provide notice to a third party or to law enforcement, for example, that there's threatened harm to someone? We also find some important duties imposed under the mental health code for mental health practitioners. The child protection law, which is part of my presentation today, is critically important to anyone who works with children. And it imposes some fairly important requirements on folks who are working with children every day. And it's very specific, the child protection law, and what your duties are and how to discharge them. And then, like I had mentioned, we want to talk about adults. There are obligations upon certain people, depending upon their profession, to report exploitation or abuse of vulnerable adults. And as our adult population continues to age, and that population just increases, obviously, the more folks we have over 70, over 80, the greater chance of vulnerability in that population and the greater chance of people taking advantage of that vulnerability. So depending upon who you are, you may have duties to report, and we want to talk about those and what you need to do to discharge those duties.
So when going through these four duties, these are some key facts, excuse me, that we found are important to keep in mind. And it really helps you analyze whether your duty has been triggered and what do you do about it. So the first thing is the role of the person making the communication. Is this person, are you hearing this from the person who is doing the aggressive act or the abuse, or are you hearing this from the victim or the survivor? And so that will impact which duties are triggered, because more than one may be triggered at any one point in time. The second critical fact is when the event occurred. Is this in the past present, or future. And depending on that timing and whether it's likely to be past and ongoing to the future, that all may impact how many duties are triggered, or if a duty is triggered. And the third thing is the type of harm itself. It depends who's involved and the circumstances surrounding that harm. Was a weapon involved? Was a weapon not involved? All of those things factor into whether a duty is triggered. And just as a reminder, more than one can be triggered in any fact pattern.
So with that, we're going to move into the substance of the presentation and cover these topics, not in any order of importance, but really in the order that we thought made the most sense here. I'm going to cover this duty to warn I mentioned. And this duty to warn is distinguishable from other duties in a couple of respects, because it's a duty that falls upon the clinical community. And it's not a am I allowed to disclose confidential information question. That's often part of the analysis. But what's important to know about a duty to warn is it's an affirmative statutory obligation to make the disclosure. So if all of the boxes are checked, and we're going to talk about what those boxes are, in a circumstance where you are a clinician and your patient has disclosed to you information that triggers your duty to warn a third party of harm or threaten harm, this is an obligation that the law imposes upon the clinician to actually discharge within a certain time frame and in a certain way. The failure to do so can result in some serious consequences, including liability. Before this statute, and it's cited in this slide, MCL 330.1946 was promulgated, it was a little bit of the Wild West on this across the country. And there were a couple of cases in the state of California where the courts were going in different directions on this, where clinicians felt, I can't report. My patient told me something in confidence, and I owe obligations to my patient to maintain that confidentiality. And we had clinicians who said, I have to report. If I don't, someone's going to be harmed. And so I'm going to breach that confidentiality. And the courts were struggling with this. So when that happens, the legislature often weighs in and says, we're going to answer this question for you, courts. And so we had these duty to warn statutes passed nearly in every state in the country. And Michigan passed its, within the Michigan Mental Health Code, it is 3301946. And here's how it works. So if you're a clinician and you're engaged in, let's say, for example, psychotherapy with a patient, and that patient communicates to you, and these are boxes that actually need to be checked in order for this duty to be triggered, a threat of physical violence, right? It's not any other type of threat. It has to be a threat of physical violence, and that threat has to be against someone who's identifiable or reasonably identifiable, so the clinician knows who this person is or can reasonably ascertain who this person is. The patient has the apparent intent and the ability to carry out that threat sometime in the foreseeable future. And if all of those boxes are checked, the clinician has a duty to disclose. And that duty to disclose outweighs the duty to maintain confidentiality, according to our legislature, in weighing these competing policy considerations. Our legislature has decided, wisely, in my judgment at least, that there are some secrets that can't be kept. And if someone is going to be harmed and we have an ability as a clinician to prevent that harm, our legislature has said, you must disclose. So how do you disclose that duty? I mean, how do you discharge that duty and make that disclosure? The statute 1946 is very specific on how you do that. You have to make a reasonable attempt to actually contact the third person and warn them if you can. And you have to call law enforcement and disclose that threat. Either the law enforcement where the intended victim resides or where your patient resides. That's the primary way you can discharge that duty. You can also, though, I refer to this as take steps to get the patient off the streets, right? So if a patient presents to you as a danger to himself or others, and if a threat is made, there's a strong possibility that that standard has been met. You can, as a clinician, quite frankly, anyone can at this point, when they believe someone is a danger to himself or others, take steps to initiate proceedings to hospitalize that patient, right? The patient is committed involuntarily into a psychiatric inpatient hospital setting where treatment is provided and released only after the patient no longer is a threat to himself or others, right? So if a patient is hospitalized, obviously the patient is safely away from his or her intended target and the threat has been eliminated. So that's how you discharge these duties. The statute will walk you through that. So, and it does in a very clear way. So it's a good place to start. But this slide kind of walks you through the boxes that have to be checked. And then once they're checked, you discharge that duty. Now, what I will say is I do get calls. You know, I would say I get a phone call from a client maybe once every couple of months on this subject matter. And the counsel I give is legal, right? It's risk management, you know, because I'm not a clinician, right? I'm not in the room when the threat is made. I haven't heard the words. I haven't seen the facial affect of the patient when they make the threat. I don't know the patient's history. Well, I can give legal advice. But what I often do, if you have colleagues within the hospital setting or in the clinical setting, where you can discuss the issue in a confidential way. I have discovered in my practice that communicating with your colleagues who are in the business with you is a really good place to start in these gray areas. Sometimes it's going to be black, sometimes it's going to be white, other times it's going to be gray. And so you having that conversation in those gray areas, right, with someone down the hall from you, without revealing obviously the patient's identity, because you'll have HIPAA and confidentiality concerns even in that arena, but just the fact pattern can be a really good place to start. So for that duty to be triggered, all of those four conditions on the prior slide have to be met. But there are some fact patterns that have hit our radar more than once, so we kind of wanted to talk about it a little bit. For example, what if a person, your patient makes a threat, not against a specific person, but a group of people? You have a student patient who makes a threat against his entire class, right? Or you have a university student who makes a general threat against the entire university population. How do you handle that? And these are gray areas, but from a risk management perspective, and because we'll talk about in a couple of bullets, the safe harbor provision, our counsel historically has been err on the side of trying your best to discharge that duty in the best way possible. And I say that because a lesson from a litigator that I have learned over time is this: I would rather be defending my client on a breach of confidentiality in a situation like that than defending my client who failed to disclose in a situation like that and great harm resulted from it. So this is classic risk management. There's risk on both sides of that equation, but my counsel historically is, if you've called me, you're probably already there in your head, and err on the side of disclosure, if that helps. We often see threats of mental harm. One fact pattern that's hit our radar in the last year or so is a patient of a clinician discloses that he maybe has a tape of some inappropriate or appropriate conduct with a third person, and he or she intends to publish it or share it. And we know that would cause significant embarrassment and significant reputational harm to that intended victim. Is that reportable? And the answer is it isn't, right? It's not a threat of physical harm, right? It's a threat of mental harm. And so it doesn't check that box, even though you very much may want to report it and you feel you need to report it. You're not going to find that safety to report in the duty to warn statute, nor an obligation to report. You may find it elsewhere, and we're going to cover some other areas here, but it's not going to be there. Now, this safe harbor provision that we reference in these circumstances, and it's important here, and this is the risk management piece, because if you report in good faith, you are protected against any civil or criminal liability from your patient for that breach of confidentiality. And what I can tell you is, in these gray areas, if the area is gray and you're talking to your colleagues about it, and you've maybe made a call to Neil or me to discuss, you've almost always hit the good faith threshold. And so now it's about managing that risk, and do we disclose or do we not disclose, depending on the type of threat that's been made, right? Who the intended victim is. We'll weigh all of those considerations. But at the end of the day, I typically find myself counseling my clients to report first in these circumstances, because the liability for failure to discharge this duty is severe. It is, you can be sued, and likely would be sued, for not discharging that statutory duty to warn. And if a death results, right, the sky is the limit on damages. And so, however, if you report and disclose and you got it wrong, and that particular patient comes back and makes a claim that you breached confidentiality, you can almost always find a safety net in the safe harbor provision in that good faith area. And you're going to be protected against civil liability. Our legislature wants to give you the freedom, when you believe that something is going on and you can prevent that type of harm, to make that report. Another question that's come up in my practice fairly frequently is, what if a threat like this is made to someone who's not a clinician? Take the receptionist at the therapist's office, or the direct care provider at a child caring institution who's not a licensed clinician treating a particular child. And that particular person becomes aware of a threat of someone in the facility. Well, you're not a clinician in those circumstances, so you do not have an affirmative duty to warn. On the other hand, if you receive that type of information in a non-clinical setting, it's also not confidential. So you have the freedom to tell anybody you want, so long as it's true and you're not defaming somebody. You can make that call, warn the third person, and you're not going to be charged with breaching any confidentiality. The general rule in this area, folks, is you typically do not have a duty as just a member of the public to protect third parties from harm. The law has not imposed such a duty on any of us to do that. However, there are exceptions to that, and those exceptions have crept into our common law where there's a strong relationship or a special relationship between either the person who hears the information and the intended victim, or the person who hears the information and the person making the threat. These areas are evolving and continue to evolve in our common law, which is what our courts address. And I typically counsel just about anybody who calls me on something like that, make the report, err on the side of protecting somebody and make the report in those circumstances. Because if there's not a case on point that has actually created as a matter of common law, which is a judicial decision, that duty, you don't want to be the first. You don't want to be that test case. So it's what a reasonable person would do in those circumstances. And those circumstances are varied. But if you can easily warn a third person and prevent harm, my counsel is easily warn that third person to prevent the harm. Call the police, warn the third person, do what you can do that's reasonable to prevent that harm, and you're going to be in a good place, I believe, if you're wrong or if you're right.
And so now we'll talk about the mental health code. And so we'll go back to these same key facts for the analysis. What we saw with the duty to warn was that the person making the communication was the aggressor. The timing of the event was in the future, and the harm that was going to be inflicted was physical. With the mental health code, these factors, it's the same facts that you need to look to, but they're different. The role of the person making the communication, this is the victim or the survivor of the abuse. The timing of it, it's in the past, and how far in the past is important. And the type of harm that's inflicted, it has to constitute criminal abuse. And I'll tell you, that is a frequent area for calls and discussion and confusion, because I have 3 single-space pages on what constitutes criminal abuse. So it's terribly murky or complicated, I should say. And then again, if this is happening, you may have another duty that's going to be triggered, and we'll talk about that. So under the mental health code, there is a duty to report criminal abuse of a recipient, someone receiving services. And that is triggered when there is reasonable cause to suspect criminal abuse of a patient. We'll talk about criminal abuse in a second, but the first part I want to hit on is that this isn't limited to the clinician or the therapy context. This is any employee of an organization under contract with the Department of Health and Human Services. So unlike the duty to warn, where the statute was drafted in a way to focus on the clinical therapeutic setting, and the common law addresses non-clinical staff. Here, there's a statutory duty for even the employee who's not in that clinical therapeutic session. So the receptionist, the janitor, the direct care provider, all of these people have this duty to report. So what is criminal abuse of a patient, a recipient? Homicide is fairly clear. It's either an intent or an attempt to kill someone, or you did kill someone. Okay, it's likely that you're not going to hear from the recipient when, if the recipient is the victim of a homicide, after that's happened. But if there's an attempted homicide, that's when that's really coming into play. The other 4 are a little more complicated. We'll start with assault. Assault is any attempt or conspiracy to commit a harm on someone. So you're hearing from the person who's going to be harmed that someone else assaulted them. Now, assault, it references, the mental health code references about 10 sections within the Michigan's criminal penal code. And those 10 sections vary in severity of assault, but it goes from everything of without a weapon to robbing and stealing with a weapon or committing some type of harm or torture with a weapon. Now, there is one important exception for purposes of assault under the Mental Health Code, and that's domestic violence, where a weapon is not involved. When you're treating a recipient and maybe you're doing a couples therapy, and you learn during that therapy session that one spouse or significant other has abused the other without a weapon, so no weapon can be involved, that doesn't constitute assault for purposes of triggering the duty to report under the Mental Health Code. And the idea there is that when you have a recipient on recipient violence or assault where there's no weapon involved, they may be in therapy together for the very purpose of trying to work on that. And so you want to try and foster that that therapeutic setting and that trust. And so that's not something that triggers the duty. For criminal sexual conduct, rape, this is, I would say, the most complicated area and the one that we get the most amount of calls on. And the reason is that you have both the degree of blood relation and the age of the victim survivor and the age of the aggressor all coming into in on this and for whether the duty is triggered or not. Some general rules to follow: if the survivor or the victim's under age 13, whether it's penetration or contact, it's reportable. If the individual is under age 16 and there's penetration, it's reportable. If the individual is, if there's force involved, if there's a disability, if there's an uncle or closer relationship, or some other type of special relationship, reportable. The issue comes in with teenagers when they're dating, and this is the complicated area. If they're under 16 and there's penetration, that's reportable. But if they're if they're between age 13 and 16, it's kind of the so-called Romeo and Juliet type scenario of, okay, well, there's contact, what do we do? Well, between ages 13 and 16, if there's contact only, no penetration, and the person is, in the other individual, the alleged aggressor in this situation, is 5 years older or more, so greater than 5 years. So a 13-year-old with an 18-year-old or older, a 15-year-old with a 20-year-old or older. When there's 5 or more years difference, that triggers the duty. If there's force or or your patient is under some sort of disability, that triggers the duty. If there's between ages 16 and 18, and it's someone with whom they have a special relationship, such as a school professional or a volunteer, again, the duty's triggered. And the idea is that we want to protect kids and in those scenarios. And we want to protect against the abuse of a close relationship. Uncle or closer also counts as criminal sexual conduct for contact only. So those situations trigger the duty. Again, we'll see in a bit that there is a safe harbor provision. So it goes back to when in doubt, report. But we'll address the other 2 scenarios here. First is child abuse. And what's interesting about child abuse as defined as criminal abuse under the Mental Health Code is that the definition is different from what you'll see with Dick in a moment for the child protection law. Here, if you are talking to the person who is the survivor, the victim, if you're talking to that individual and you learn that anyone with authority over that individual, as a minor child under 18, anyone with any amount of authority or custody over that individual commits child abuse, and will, as defined, and it's a physical harm or a serious mental harm. That's reportable. And what's different in what you'll see in the child protection law, what's different is the child protection law requires a special relationship, and there's 5 defined categories of relationship where that's triggered. Here, it's a much lower standard for who has authority or control over the individual being abused. Now, child abuse, there's 2 things, and this is goes to the type of harm. For your physical harm, the lowest threshold for triggering, this isn't the only, it could be more severe. The lowest threshold is when someone failed to act or committed a reckless act that resulted in physical harm, or you have the situation where an individual places another at unreasonable risk of harm, and regardless of whether that harm occurred. So you might recall a couple of years ago, there was that Australian guy, I forget his name, he dangled his baby over the alligator pit. That's placing a child at an unreasonable risk of harm, regardless of whether the harm actually occurred. The alligators are chomping beneath them. So that's the situation here. So if that little baby came and could talk to you and said, you know, this is what happened, that's placing on an unreasonable risk of harm, regardless of the fact that no harm actually occurred to that child at that time. The other situation, and unlike the duty to warn that is strictly a physical harm, here, if you have a serious mental harm to a child, that also triggers the definition of criminal abuse and triggers the duty under the mental health code. Now, serious mental harm is where you have, it's not necessarily permanent, but it is a visibly demonstrable manifestation of a substantial disorder of mood or thought that significantly impacts the child's judgment, behavior, capacity to recognize reality, or ability to cope with ordinary demands of life. Now, that's a mouthful. If you have questions, call. And when in doubt, disclose. But that is where this is where the type of harm is important. Mental harm, serious mental harm, can trigger the duty. And the last thing that is defined as criminal abuse under the mental health code is vulnerable adult abuse. And so we have to address who that is. For an individual to be a vulnerable adult, they have to be over age 18 and one of 3 things. First, due to age, developmental disability, a mental illness, or a physical disability, they require supervision, personal care, or they lack the personal skills and social skills to live independently. A second category of vulnerable adult is an adult in need of protective services under the Social Welfare Act, and we'll see that definition in a moment when I present that after the child protection law. And the third is a person in an adult foster home. So if you have an individual that falls within one of those categories, they're a vulnerable adult. Now the question is, what harm that you're hearing from this person? Again, mental health code is the individual being subject to the abuse. The victim or the survivor is the one reporting it. There's 2 types: physical harm, or again, serious mental harm. Physical harm, the definition mirrors the definition of child abuse. It's an act or a reckless failure to act that actually causes physical harm. And Physical harm is also defined as placing that vulnerable adult at an unreasonable risk of harm. It's an intentional act that poses an unreasonable risk of harm to that individual, regardless of whether harm actually occurred. Now, the other category that will trigger criminal abuse for a vulnerable adult is serious mental harm. And that definition again mirrors the child abuse one, in that it's a mental injury that results in a substantial alteration of mood, of mental functioning that's manifested in a visibly demonstrable manner. You have to have some objective evidence of it, but it's affecting their subjective mood and how they're relating to the world. When you have reasonable cause to suspect criminal abuse, one of those 5 categories of abuse, of a recipient, a patient, you have to do an oral report to law enforcement where the recipient is or the abuse occurred within 24 hours, and follow up with a written report within 72 hours. There's 2 exceptions here. The first is, you know that it's already been reported to law enforcement. The individual may tell you, this happened to me 2 weeks ago. And in the course of discussing the abuse, you learn that that individual called the police right then and there and reported it. At that point, the duty's not triggered because you know it's been reported to law enforcement. If you don't know or you're uncertain, report. Because again, when in doubt, report. And you do that because of the safe harbor provision that I'll talk about in the next bullet point. The second exception here is when you know that more than 1 year has passed since the abuse. And you may ask, well, why is that? Why do we have this 1 year threshold? Well, an individual may be coming for therapy to deal with the trauma of being abused as a child, and they're now, a senior adult. This happened 40-some years ago. Your duty's not triggered at that point. The idea is you want to protect the individuals from abuse that is occurring, that's been recent. So if there's more than 1 year passed since that abuse, you don't have a duty to report. Now, if you're not certain, when in doubt, report, because of this safe harbor provision. If you're doing it in good faith, you're protected from liability from an unauthorized disclosure of confidential information. And that's important. So again, if you're talking with your colleague, if you call Dick or me, and you're saying, is this really triggered? You're most likely in that good faith area. And so we want to protect those who are vulnerable, those who are being subjected to abuse and criminal abuse. And we do so by requiring the disclosure of information and reporting that abuse to law enforcement. Dick's going to now talk about the child protection law.
So the child protection law is likely what most of you are familiar with. It's talked about, I think, more publicly than any of these other duties. And it's really a critically important body of law in Michigan. Every state in the country has some version of this. The health and welfare of the children of this country are a #1 policy concern. When it comes to child protection law reporting analysis, we have to look at a handful of different issues. Who's made the communication to us, i.e., how did we learn of this potential abuse? Did we hear it from the abuser himself or herself? Did we hear it from the victim? Did we hear it from a third person? Did we hear it from a survivor of a serial abuser who has abused many people? When did the abuse occur? What is the harm that was inflicted upon the victim? And always, and we have to keep this in mind, we wear many hats. And is there more than one obligation to report that's implicated when we hear about the abuse of a child? So all of these questions we need to begin to ask ourselves. So who does this duty apply to? Well, I think we've all heard of the mandated reporter, right? So this is a pretty easy question to answer because Section 3 of the Child Protection Law will clearly list who the mandated reporters are. And so these clinicians, school personnel, clergy, childcare providers, and on. What do these mandated reporters have in common? Well, they are people who are best positioned in society to recognize that a child might have been harmed or is being harmed. And so the legislature has created essentially a laundry list of all of those folks. A little segue, someone told me that one of our states, I can't remember which, has imposed a duty to report abuse upon hairstylists because they are, first, confidences are shared to hairstylists that, right, that we wouldn't normally share with anyone else. There's just that culture, but they're cutting hair and they can see bruises. They can see those injuries. They're close up. And so their hairstylists, whether there's a duty or not, are often counseled, right? That they have to be on the lookout for these things. So it's the mandated reporters are those who are best positioned to recognize and stop abuse or future abuse. And if you wonder whether you are one, you can go to Section 3 and see if your name is on the list. You're not going to be named, your profession. So when is this duty triggered? Well, you have to have reasonable cause to suspect child abuse or neglect. Now, there is no statutory definition of what reasonable cause is or means. But anytime our legislature uses the term reasonable, what they are saying is, or at least what our courts have interpreted that term to mean is, what would the normal, everyday, reasonable person do in a similar or identical situation? So if the common Joe has information and a reasonable person would conclude or suspect abuse or neglect, the duty is triggered. It really is, you know it when you see it kind of analysis. But there are these gray areas. We're going to talk about some of them that do come up. One question that has come to my attention fairly often is whether the person who's received information about potential abuse or neglect should conduct any sort of investigation first to determine whether that information is reliable, true, or fantasy or make-believe. Should that person try to investigate whether we really have a situation where abuse or neglect occurred? And I can tell you that the Michigan Department of Health and Human Services and its CPS and MIC unit, maltreatment and care, would say absolutely not. If you begin an investigation, you probably have reasonable cause to investigate. And if you have reasonable cause to investigate, you probably have reasonable cause to suspect. And if you have reasonable cause to suspect, the duty to report is triggered. So I believe our courts and certainly DHHS will and have taken the position that the investigation should be left in the hands of DHHS in the system and not in the hands of the person who received the information. That's not to say that you can't investigate if you're an institution, a school, a hospital, contemporaneously with a outside investigation. You, as an employer, have obligations to your institution and to the children under your care and to your staff. You, in my judgment, you certainly should investigate and take remedial action even if DHHS and law enforcement are also conducting an investigation. The key there, folks, is you just cannot interfere with their investigation. You can't get in the way. But you also, as a lawyer, I've counseled my clients, your obligations to your children, your staff, your institution are also critically important, and you should engage in your own investigation. Just stay away from their investigation and don't give them any reason to suggest to you that you are interfering in some capacity with a CPS investigation. Child abuse or child neglect, what do you have to suspect in these circumstances? Well, these are defined terms in the child protection law. Child abuse is non-accidental physical or mental injury, sexual abuse, sexual exploitation, or maltreatment. Child neglect is negligent treatment or placing the child at an unreasonable risk, right? An unreasonable risk to health and welfare, even if the child's health and welfare haven't been affected. If that risk is there, child neglect is checked. So if you're wondering whether you have met that standard, you can refer to the statute itself. You can discuss with your colleagues, and you can certainly call your legal counsel to walk through whether those boxes have been checked. Now, what I want to point out is we have a bullet here that says you need a special relationship, and it's critically important. There's a misnomer out there about whether we have to report, whether we have to, meaning we are obligated as a mandated reporter to report all abuse and neglect of children. And there may be duties to report in other areas of the law, but for that obligation to report to be triggered under the child protection law, there has to be a relationship, which we refer to as a special relationship between the child and the abuser. And I don't want to paraphrase this, I want to get it right. So the law requires that a mandated reporter who has reasonable cause to suspect child abuse or neglect make the report if that child abuse or neglect is committed, here it is, by a parent, by a legal guardian, by any other person responsible for the child's health or welfare, by a teacher, by a teacher's aide, or by a member of the clergy. It is those categories and those categories alone of individuals who, if we have reasonable cause to suspect, have abused or neglected a child, and we are mandated reporters, we have an obligation to report. Now, I'll caution you, and I'll actually give you a safety net. You can report anyway. Nothing prevents you, unless there's some confidentiality concern that is implicated. You can always make a report that a child's been harmed or abused. Even if you're not a mandated reporter, even if there's not one of those special relationships. Quite frankly, it's not even a legal issue. It's, I think, possibly a moral issue. I think there is a obligation to try to help that child and to make that report, even if those boxes aren't checked. But the child protection law only requires that the report be made under these circumstances. So let's talk about a couple examples here. And these are real examples that have come to our attention over the years. So we are a mandated reporter, and we receive information that a child has been potentially abused or neglected by a family member who's not a parent and isn't a person responsible for that child's health or welfare. Well, that person is not in that special relationship with the child. So the duty to report is not implicated under those circumstances. Now, this is a thought we always have to consider. If the parent has left the child with a family member who's not in that special relationship, or is allowing the child to be around a family member who is not in that special relationship, and that family member is abusing or neglecting the child, do we have an obligation to report the parent for placing that child at a risk of harm under the neglect standard? And I think there's a very strong argument that we would. So the report in that circumstance wouldn't be against the abuser per se. It would be against the parent who's in the special relationship with the child for exposing the child to that family member. So there are different ways to approach this, and you have to be thinking outside the box sometimes. Parents who are incapable of providing for kids, if it checks the neglect box, we have to report, and we need to get these kids help, even if there's no intent to neglect the children. There's not an intent standard, it's neglect. Where minors are involved in sexting each other, and we become aware of this and our capacity as a mandated reporter, we've seen this question. Well, there's no special relationship between these minors, but if the parents, if there's a risk of mental harm to these children because of what they're doing, and the parents, we believe, are allowing this to happen and have some knowledge, we may have an obligation to report the parents, not the minors, but the parents. Minor on minor abuse, same analysis. Is there someone who's in the relationship with the minor who would be the target of a report? Needs to be investigated. If that person is removed from the situation, this abuse could stop. We have to ask, is there a parent or someone else out there who is allowing minor on minor abuse to occur? Date rape, if it's minors, no. If it's an adult and a minor, not under the child protection law, unless that adult is in that special relationship that we've talked about. But there may be other obligations to report as well. Now, again, you're not obligated to report, but unless you're bound by some ethical confidentiality concern or a statutory requirement on confidentiality, you can freely report any of these things. What happens if an adult discloses past abuse upon a child, but that relationship wasn't there? Same analysis. If that adult was not in that special relationship with the child, you are not obligated under the child protection law to report, but you may and likely have obligations to report under other sections of the law that we've talked about today. And you're certainly free, unless bound by confidentiality, to disclose. And a real interesting one here is past crimes, right? We learn of past abuse of a child. Well, if we learn about abuse of a child, it's always going to be in the rearview mirror, right? It's ongoing, but we've learned that it's happened. So it's always past per se. But what if we have an adult patient who discloses to us that his parent years ago abused him or her? Do we have an obligation to disclose under those circumstances? It's very gray, right? If that parent, let's say, is now in a nursing home and not around children, potentially not. If that parent is deceased, potentially not. The concern we would have to ask ourselves, though, is that parent around children today? Does that parent have minor children under his care? Is that parent a teacher, right? All of this is designed to allow the system to intervene, to stop harm from continuing, to punish those who have committed that harm, and to protect children. In these gray areas our counsel is to err on the side of making a report. How do we make this report? How do you discharge this duty under the child protection law? Again, the law is very specific on what we have to do. Once we hit all of these boxes, we have to immediately, what I would say is as soon as practically possible, make a verbal or online report to DHHS, which is the parent governmental entity of CPS. They have a centralized intake for fielding all reports of child abuse and neglect. You have to make that report immediately, verbally by telephone, or through their online portal, and they have one. If we do it verbally and not in writing, we have to follow up with a written report to the same entity within DHHS, which is their centralized intake unit, within 72 hours of making that verbal report. So we've got immediately to make the initial report, and if it's done verbally within 72 hours, we have to follow up in writing. Now, if you've used the online portal and we've made all of the written disclosures for that report, we've done so in writing. But again, when in doubt, call CPS, ask them if you've done it properly, and make sure you're protected there, because there are criminal penalties for not discharging this duty. You can be charged with a crime, and certainly, like all of these other areas, there's civil liability. If you don't report and you were supposed to, and a child is hurt, you can be sued and civilly liable for those damages. Another point, it's not on the slide, but it happens in institutions. If you're a mandated reporter working for, let's say, a school system, you're a teacher at a school and you have reasonable cause to suspect the abuse of one of your students, and you report that abuse to one of the administrators, right? You, as a matter of policy, likely you tell the principal, I've got this concern, you make that report. You have not discharged your duty as a mandated reporter unless you get confirmation that that administrator has made the report. You have to see it through if you're a mandated reporter. It's not good enough just to tell your boss or tell someone else within the institution. As a mandated reporter, I say, you've got to see it through to the end. You got to make sure that that immediately gets to DHHS, that you make the written report within 72 hours. Either you do it or the system does it. Someone within the system does it on your behalf, but you have to ensure that that happens.
And finally, we have the Social Welfare Act, which is a unique statutory creature, but it is designed for vulnerable adult abuse. And again, we have the same facts that we need to analyze. Who's making the communication? When did it occur? The type of harm? And always keep in mind that a duty here, this duty to report vulnerable adults abuse here, may also trigger another duty, such as one under the Mental Health Code. So what is it? Mandated reporters are incredibly broad under the Social Welfare Act. It extends to employees of healthcare institutions, any educational institution, any social welfare institution, mental health institution, or other human services agencies. If you're interacting with people, everyone from the receptionist on up is a mandated reporter when they learn about vulnerable adult abuse. We want to protect our vulnerable adults. And what's unique about the Social Welfare Act for vulnerable adult abuse is that it has an optional reporter provision. And that is, if you don't fall within the mandated reporter, which is anyone interacting with people, you can still report. And it's right in the act of having an optional reporter. So when is that triggered? It's triggered when you, as observing this, suspect or you have reasonable cause to believe that an adult has been abused, neglected, or exploited. And these are three different categories of situations, or three different types of situations. But first, what's that vulnerable adult? Who are we looking at here? They have to be over age 18, and they have to be unable to protect themselves because of a mental or physical impairment or because of advanced age. So what's interesting here is I know a guy who's 94 years old and sharp as a tack, in great shape, but he would still qualify as advanced age. And so he would still fall within the definition of vulnerable adult. What is abuse of a vulnerable adult? This is harm or threatened harm to that vulnerable adult's health or welfare. And that includes non-accidental physical injury or mental injury, sexual abuse, or maltreatment. It's by anyone. There's no special relationship. It doesn't have to be just by that individual's child. It could be their neighbor. It could be, the kid that drops off their newspaper. Back in the days when we had newspapers, and sorry, that just dated myself there. So we have a lower threshold than the mental health code for this abuse. What's neglect? Neglect is, again, harm to health or welfare caused by, and what's interesting, the adult's inability to respond to a harmful situation. So because of their mental or physical disability or advanced age, they can't get themselves out of harm's way. Or, neglect is also, conduct of a person who assumes responsibility for a significant aspect of that adult's health or welfare. I recall a phone call where someone said, I was in a therapy session with an individual. That individual's sibling was supposed to pick up groceries every single week for their parent who was homebound. And the individual was reporting that that sibling was not, in fact, picking up groceries, was just leaving the parent without food. That is conduct of a person who's assuming responsibility. The sibling was assuming the responsibility to pick up groceries for the homebound parent and was failing to do so. That's putting the parent and meeting the definition of neglect. And because that was reported to an employee of a human services agency, that employee is bound to report. Now, what is not neglect is something we hear about in the news, and it's the religious exemption. If the only reason why you think that an individual is being neglected is because they are relying on prayer to heal themselves or to handle the situation, and that prayer is pursuant to a recognized church or religious denomination's tenets, if that's the only reason, that doesn't constitute neglect for a vulnerable adult. Exploitation is the third category of mistreatment that would trigger the Social Welfare Act's duty to report abuse of a vulnerable adult. And exploitation is misuse of the adult's funds, property, or their personal dignity by anyone. Again, no special relationship needed. Unlike the child protection law, we want to, this is applying to anyone who's doing this to that vulnerable adult. And so we have a couple hypotheticals here. What happens when we talked about that clients talking about a sibling not caring for the parent? When that sibling assumed the duty to provide those groceries every week, that's neglect. What about a parent giving a caretaker money? You see this often in conservatorship proceedings. child maybe lives out of state, parent has a caretaker, parent pays, parent feels bad for that caretaker, pays them, for when they don't come, pays them different things, gives them a large gift at Christmas or something. That's a gray area. And it gets further, it's murkier, when you consider the vulnerable adult's age. Is it different when they're 60 or 90? What's advanced age? If it's, is there a different result if that caretaker who's getting the money is family, like a child, or non-family? And so it gets into what I would call like an uneasy gray area. And in those situations, call Dick or me, or, and know that you have a safe harbor provision. If you're reporting in good faith, you're protected from liability. What about when a friend tells you of abuse, neglect, or exploitation? Again, there's not a special relationship here. So if it's meeting these, if it's a misuse of the funds, if it's meeting the definition of neglect or the definition of abuse, even though it's a friend, and you have the right to report. You're an optional reporter under the Social Welfare Act. And so how do you discharge it? You've learned of abuse of a vulnerable adult. The first thing you do within 24 hours is an oral report to the county social services agency where that adult's at. And you follow up within 72 hours with a written report. I referenced the safe harbor provision. If you're immune from civil liability for the report itself, because the presumption is that you're acting in good faith, that doesn't mean you can make a false report. That doesn't protect you from, making a false report. That's if you suspect or have reasonable cause to believe that vulnerable adult abuse is occurring, you can make the report and know that you're protected from that liability. Your identity is confidential, absent a court order or your consent to waive it. And most privileges are abrogated. And what we're talking about here is, for example, attorney-client privilege is actually one that is not abrogated. I suppose it helps to write the laws. But other than attorney-client privilege, if you have a privilege that may apply, like clergy, parishioner privilege, that is abrogated and you can report the information. Since and may in fact have a duty to do so. What happens if you don't report? You have your own civil liability for any damages, and what I'm talking about there is harm, injury to the vulnerable adult that resulted from your failure to report. And, you can have a civil fine of up to $500 per failure to report. What happens if something doesn't neatly fall within one of these categories of mandated reporting? What do? And can you disclose? There is a provision in the mental health code that provides for the discretion of the holder of the information that they can disclose to a public agency when there's a compelling need to disclose. And that compelling need is based on a substantial probability of harm to the patient or someone else. Now, what's interesting here is the employee who goes rogue, the discretion of the holder. I've interpreted this, and I'm curious if you agree with me here, Dick, that the holder is the entity, the provider, so the agency providing the services. The holder is not the individual clinician. It is that entity holds it. And so it's that entity's discretion. The employee themselves can't go rogue and report and make this their own decision. It's the entity's decision because it's the entity's liability as well. And so and you agree with that?
I do.
Yeah. So when that occurs, you can disclose. What's important to keep in mind here is there's not a safe harbor here. You're not, there's not that provision that says you're protected from liability right in the statute. But again, the lesson from two litigators here is any day of the week, I'd rather be on the side of defending an allegedly unauthorized disclosure of information when you are trying to act to protect someone who is being abused than in the position of defending why you didn't do that when a significant harm occurred. And so we have a couple resources here for you for each of these duties. Again, Dick and I are happy to talk and frequently have conversations on, whether the duty is disclosed. How do you do that? How do you document it in your own records that a disclosure was made and why, or why you didn't disclose so that you're protecting yourself? Those are all conversations we have on a regular basis. I don't know whether we have a question.
We do. We have one question, and I can answer it now. It's actually a really good one. Here's the question, folks. Are there any legal considerations to keep in mind for individuals that may not be obligated to report abuse or neglect outside of a clinical setting, but would like to do so regardless? For example, staff in an apartment complex that suspect a tenant is leaving a child alone for extended periods of time. It's a really good question because there is no statutory obligation to report in those circumstances. Our legislature has not passed a law that requires apartment complex staff to issue reports like that, nor is an apartment complex staff a mandated reporter under the child protection law. But you would like to report. Well, report, please, right? And so our counsel would be, you are free to always make a report, even if there's not a statutory obligation to do so, unless you're in a clinical setting and there's a confidentiality you must maintain, right? So in this circumstance, you are absolutely free to report. Are there legal considerations? I am not aware of a case that has created a common law duty in a circumstance like this. I, however, would not want to be that first case. So if there's a child left alone in an apartment complex and staff at the complex for weeks has suspected that that's the case and they've done nothing and that child is hurt or God forbid dies, and the apartment complex and the individual staff are named as a defendant in a lawsuit, I would be fearful that the courts could create a duty under those circumstances and say there is a strong enough relationship between the staff and the tenants of a building where we are going to recognize a duty because a reasonable staff member would have reported, and we think an obligation to report there under those circumstances exists. There is no such case that says that, but under these circumstances, if you called me, I would say pick up the phone and report. In fact, with your permission, I might make that report for you. So a really good question. I hope that answers it.
And here is our contact information. If you have any additional questions or you're wondering, does this apply to me? Does this apply to my entity? I didn't get a chance to type it in. Feel free to reach out to us. We're happy to help. We enjoy working in this space and in this area. And our goal is always to provide quality, efficient counsel, but give you the peace of mind to know that you're protected and you did the right thing.
Thanks, everybody. You know how to reach us if you need us. Take care and have a great day.
Take care.